Okay, so am I audible? Let's begin. So this is the chapter 2, which says the Partnership Act 1932. We already did complete about the Contract Act, I would say 1872. Yes, in chapter 1. So now let's begin with the chapter 2, the Partnership Act 1932. Basically, let's discuss about what first its meaning, why it is necessary, why it is existed. So normally it is generally between 2 to 50 peoples. Between 2 to 50, minimum it required 2 people, maximum 50 people. Let's read. Okay, definition. The Indian Partnership Act 1932, Section 4 defines partnership is a relationship between persons who have agreed to share the profit of a business, carried by all or any of them acting for all. Let's break down word by word, so it feels complete and logical. We are going to breaking the definition part here. So the first is relationship between persons. What here means is that in partnership, it is a relationship between at least two people. It is mentioned, and it is relationship, not a one-time deal that binds them in a business. Basically, the relationship here doesn't mean it's a one-time thing. Basically, here if they allowed in a partnership act and they did, so they are binding by I would say a legal force that binds them in a business where they have to perform, I would say, commercial activity. We'll discuss it later. Like on the second feature, it says agreed to share profits. There must be an agreement or an oral or written to share profits and usually losses too, even though law mentions only profit. Okay. The third is of a business. It is very important because it must involve a continuous commercial activity, not just owning property. Sometimes, so basically, the definition says the when two or more people come together to share profit, uh, and where we will come together to share profit of a business which binds them in a business in which where any of them carried on by all or any of them acting for all. So you will see the connecting each feature is connecting the definitions dot. Here is also one example, so you can relate it if you are not getting the definition part here. Because I'm just putting too much pressure on this because it is very essential. If you don't get the definition now, if you don't understand the partnership act, you won't. Basically, this is the foundation. So I want you to give it time and read it properly. If you can pause the video as well. So the last part here is carried out by all or any of them acting for all. Basically, it is a mutual agency. So its term is meaning it's mutual agency where it is mentioning that there is, let's say there are 5 partners. So every partner can represent the other partner as well. So that is what it is mentioned here. This is the core element called mutual agency, which means every partner can act on behalf of the firm and all are bound by the act. Now let's make your definition complete in simple full form. Okay. So partnership is a legal relationship between two or more persons who agree through a contract to share the profits and losses of a lawful business carried on by all or any of them acting for all who are jointly responsible for a business liability. So this is a complete definition that you can trust and rely on and for your life, to be very honest. Now moving to the topic 2. In topic 1, we just discussed about the definition and its features, and its core features, I would say. I would say only definition because in topic 2, we are going to discuss about the essential features of Partnership Act. So first is agreement-based relationship. What does it mean? It means partnership doesn't arise automatically. There must be a mutual agreement, written or oral. Without agreement is not a partnership. So basically, in this part, in this first feature, agreement-based relationship, it is a relationship where uh, I would say legal force binds the partners onto a business or a commercial activity that they are going to perform for, I would say, like for future. journey. So it is something like that. A lawful business. What their partners are trying to do has to be lawful under like lawfully passed objects. Basically, no illegal trades is allowed here. In this second feature, it is mentioned. I'll just read it for you. The business must be legal, not gambling or smuggling. Otherwise the contract is void. Okay. The third feature here is profit and loss sharing. As you know that every partner is share their profit and loss in the whatever ratio they mentioned in their partnership deed. We'll read about it in the next coming topics. So I'll just read what is written in here. You must share profits and losses. Sharing proves that mutual involvement. Okay, in mutual agency. Remember, we just discussed in the definition also. In mutual agency, it simply means that one person acting for all the acting in on behalf of the firm as well as for the other partners too. Simply, let's read out what has been written in here. Each partner acts as both agent and principal, can bind the firm and is bound by other acts. This is heart of partnership. Your partner signs a supplier contract, you are also liable. It simply means that if there are five partners, if one of them uh, signs a check on behalf of the firm, so he is able to do that, and the bank will consider it also. And the other four partners should accept this because they are the partner. They are under the partnership act. So it works like that. The next feature is unlimited liability. Okay, in partnership act, the partners have their unlimited liabilities because partners' personal asset can be used to pay firms' debt. Obviously, unless your partnership act is not LLP, which we are going to learn about LLP in the upcoming topics. So don't worry about that. The next feature here is number of partners. It is simple, minimum 2 and maximum 50, as I mentioned. Voluntary registration. So in here in Partnership Act 1932, it is not been compulsory to register, but it is, I would say, suggested we have to be registered because many complications that might appear in future will resolve initially, so it really helps for future journey of the firm. So the next is joint ownership of assets. All partnership, all partners jointly own firm's property. No one can sell it alone. So okay, don't confuse between the mutual agency and joint ownership of assets. In joint ownership of assets, normally, if any partner cannot sell any firm's personal asset, he or can take decisions on the behalf of the other partners or on the behalf of firm. But that decision should not be about selling an assets. Remember that very clearly. Okay, this is a small diagrammatic representation that if you don't know anything about partnership act, you don't know, let's say, that exact definition or something, if you can simply say partnership act is a is a is a partnership of between the partners where the partners are responsible for very three important activities. The first one is um, partnership rights, partnership duties, and partners liability. The partnership partners' rights are profit sharing, participate in management, access to books. Partnership duties are like good faith and honesty, no, not to compete. And the liabilities are unlimited liabilities, third party acts, shared losses, things like that. So basically, in this one image, you know how to. Basically, it is for partnership deed, but you can also apply it in partnership act because it is more or less, I feel, the same only. But I prefer you to remember the original definition because it is not that tough, and yeah, you will get used to it. The second image, I would say, it's been about the partnership. A small is a form of business where two or more persons come together to carry a business with a view to share profit. Top features like mutual agency, profit sharing, unlimited liability, agreement based formulation. Classifications are general partnership and limited partnership. In general partnership, we are going to learn about both Like there are certain, I would say seven types. Okay. There are certain seven types of general partnership. The first one is active partner. You probably know about it, so I just read out its meaning. Actively participates in business, operations, and management. Represents the firm. For example, you handle supplier, staff, and daily cafe operations. It's like that. Now moving to the second, sleeping or dormant partner. What does it mean? It means that contributes capital and shares profit, but doesn't take part in daily business. It is called as sleeping or dormant part. For example, your friend invests 2 lakh but never visits cafe. So it come under sleeping partner. And the third is nominal partner. Only lends his name to the firm, doesn't invest or earn, but becomes liable to outsiders as a partner. For example, I hope that many of you heard about that this person has an Amul agency. What does it mean? He has his partner is Amul, but here the partner is a nominal partner. He just gave their name to the some other, like say a person, and a company, a firm. So it works like that. Just on the basis of trade between and they will get their license, and on the basis of that, in return, they'll get their goodwill. So Amul goodwill is like on top in terms of all the dairy products. Now moving to the next type of partner. The next is partners in profit only. There are this, as the name suggests by itself, in that the partners are only liable to share are not liable to share any losses. They only share their profits. Limited partners. In limited partners, their liability is limited to his investment. Only possible under LLP. Okay, it is under LLP. Then the minor partner. So basically, just remember this three to four types that are very essential, important for you. This is a diagrammatic representation. You can visit this also. So till now, what we have learned, let's quickly revise it. So we just first come, we just know about Partnership Act. It is an act that comes under 1932. So basically, it is an act where two or more partners come together uh, for to run a commercial activity that binds that help that generate profit, and they share the profit among them, and also liable for the liabilities there in the firm. So it works like that. We read about the exact definition. We also read about uh, the top features. I'm not remember the complete feature, but it is something like agreement agreement based. Second is number of partners. It is between 2 to 50. The third is, I'm not getting it. Mutual agency. Yes, correct. Mutual agency, lawful business, profit and loss sharing. That's it. Is more than enough. So the third is types of partnership. Okay, let me think. The first is active partner, who is actively working on business on daily basis. The second is sleeping partner, who is just not being able to there on daily basis, but gives uh, investment and shares profit. That is sleeping or dormant partner. The third is a nominal partner. In nominal partner shares their name in the exchange of goodwill that they have. Uh, yeah, they are not just coming on daily basis, or not sharing their investment, or not investing in business. And then last, I would say profit sharing partner, or something like that. Partners in profit only, or something. Okay, so this is something what we have learned. We are going to move to the topic 4. It is about partnership deed. So now there it is suggested that in Partnership Act, if you are opening a partnership, so you should make a partnership deed. What is a deed? Like many of us, even I also think that partnership deed is not necessary. So why should we invest our money in that making a deed? Because obviously any legal work will take a lot of time, efforts, and money. So, but this is very important. Why? Let's study with a simple example. Why this topic exists? The need. Imagine, like for example, I am Pratik. So imagine Pratik and you and your two friends start a cafe together. Okay. At first, everything's fine. You trust each other, but after a few months, one friend says, "Hey, I deserve 60% of profit because I handle customers." I disagree, saying you invested more, so you should get 60%. So basically, there are two people out here. The first is saying that I should get 60% because I am working more, I am engaging good customers, I am maybe bringing the new clients. But the first one says, the other partner says that no, no, initially I invested much more money than you, so I deserve 60%, not you. So basically, these are the very basic examples. And yeah, disputes happen in the future. There's a suggested, I would say, we write a deed. Basically, what is deed? Partnership deed. Partnership deed, basically, let's read this also. If there is no written agreement, then, as per the law, all the partners are assumed to share profit and losses equally. No one gets salary, no, and disputes become messy. That's why a written document deed exists to clearly record everything. So let's break it down step by step. First, partnership deed. What is partnership deed? Let's read it out. Just a second, guys. Okay. So partnership deed is a written document that contains the terms and conditions agreed upon by all the partners. Basically, it is nothing, just a written document that states what are the terms and conditions that all the partners has agreed at the very beginning. So it is basically like the constitution of your business partnership. It tells what to do, what not to do, and how to solve the issues. That's it. That is what all partnership deed contains. So let's move to the original definition. Partnership deed is a written agreement that defines the rights, duties, and obligations of partners among themselves and with the firm. Now, I imagine that you very clearly understand the initial picture which I just mentioned, that it is about a partnership deed. The three important elements that partnership deed stands on: partnership rights, partnership duties, and partnership liabilities. And if you want to know more about it, it is partnership deed is nothing but just a written document where uh, it is mentioned what the partners should do, what they should not do, and how to resolve the issues if any issue arise in the future about the business, around the business, I would say. So it just tells about that. It is as simple as that. Don't complicate it. Now we'll understand about what are the contents, or we can say clause of a partnership deed. Like what are the clauses? So first is basic details, like name of a business address, nature of business, duration, fixed or indefinite or something, capital of profit sharing, management and operations, like who manages, who assigns, who does what, which, like who is the CEO, who is CFO, something, rights and duties, decision making powers and duties, administration and retirement, process of to admit a new partner, how it is to be done, accounts and audit, maintenance of books, audit or something, dispute resolution. So basically, there are around eight clauses. So obviously, you should make sure that you learned all of these things. Basically, you just had to run this because uh, this part, I think the name itself suggests how to what does this clause include and why it is better. So let's move to the third part. We understand the first part as I would say partnership deed definition. The second is the clauses, and then now we are going to learn about what is the registration of a partnership form looks like. So now here's where the student get confused more often. Is registration compulsory? No, it's not compulsory, but it is been mandated. I would say recommended, but it's highly recommended because unregistered firms lose several rights. So yeah, you can just let's check it out first quickly. Basis legal recognition. So registered firm has a separate legal registration. Unregistered firm exists but not legally very strong. Right to sue. Registered firm can sue third parties or partners, whereas unregistered firm cannot. Partners protection. In registered firm, yes, the partners can sue each other on or the firm as well. Whereas in the unregistered firm, no, they can't sue each other or the firms. Public record. Public in registered, it is publicly available, whereas it in unregistered form, it is not. Government tenders. So yeah, usually they are eligible, but more often in registered form they are available, but in unregistered form they are not being. They are mostly rejected, I would say. In overall status, uh, registered forms are safe and transparent, whereas unregistered forms are risky and limited. So if in future, let's say you guys are going to uh, come under or start any business, or maybe decided to go for a partnership act under 1932 of this. So I would suggest you to make a partnership deed. It is highly beneficial for you in the long run. Okay, now moving to the conclusion part of this. Okay, just a second, guys. Mini summary: partnership deed, a written agreement defining partners' terms. Need to avoid disputes and clarify profit, duties, and rights. Registration, optional but legally, but gives legal protection. Authority, registrar of firms, yes, state government. So basically, now we understand about the how to register the process, why it is necessary. No, but okay, this part is left. I think that we just complete why it is necessary for a business to register as a partnership deed or made a partnership deed. Now we'll understand how to register a process in simple flow. So if you started a partnership act and you decided that you are going to make a partnership deed, then how will you go for it? So first, fill form A, form name, address, partners names, duration, nature of business, attach partnership deed, fees, submit to registrar of firms of the state. Registrar checks and enters in register of firms. Okay, issue of certificate of registration. Okay, it is simply like first you need to take a document of form A, then fill all the necessary details of your firm, then attach it with the partnership deed that you feel that we are going to follow. Basically, you and your other partners are going to follow. Then add it with some fees or some amount, then submit it to the registrar. I would say state registrar, and then the state registrar is going to I would say edit that uh, edit your form in the register of forms, and then after that registrar issued a certificate of registration. That is how this thing functions. Yeah, now moving to the fifth topic. What are the rights, duties, and liabilities of partners? So it is very simple. It is so basically why this topic exists. Okay, why it exists? Because when multiple people run a business together, conflicts are natural. Obviously, you also see in your around in your surrounding that many people are facing this issue. Who takes decisions? Who represent the firm? Who pays if something goes wrong? This topic ensures clarity in behavior of partners within the firm to maintain fairness, accountability, and trust. Let's split this into three parts. So there are going to be problems. So, on the basis of first the rights of partners, then we understand the duties of partners, then we understand the liabilities of partners. In terms of rights of the partner, what are the rights that the partner has? The first right is to participate in the business. The second is to share the profit. The third is to right to access the books. The next one is the right to be indemnity. Now, this understand it, listen to it very carefully. What does it mean? If one partner pays on behalf of the firm must reimburse to that partner. So we can say it as a right to be indemnified. Okay. The fifth one is right to interest on capital. If deed mention, partners get interest on invested capital. Right to use partnership property. Okay. So these are the rights, right to act in emergency. Okay. So these are certain rights that every partner has. Now move to the duty. What a partner must do ethically and legally. Not compete with the other partner. Follow the all the lawful subjects. Uh, make sure their accounts are clear. Something like that due to and that indemnity for fraud. Basically, don't just overshow money and make reimburse with the firm. Don't do that. Duty to not compete or something. Now liabilities. So there are unlimited liabilities. Like obviously, partners' personal asset can be used to pay firm's debt in Partnership Act 1932, but it is not in LLM. No, sorry, not LLM. It is LLP. Yes, limited liability partnership or something like that. We'll read about it in the next topic. Yeah, joint and several liability. Every partner is liable for the firm's debt jointly and individually. Now, going to the third one, liability for acts of partners. Firms bound by acts done by any partner within the business scope. Obviously, if let's say we are five partners and one of them has written a check of 5 lakh to a wrong person, to a wrong creditor, I would say. So it has been a mistake considered by all of the other partner as well. They are also liable for it. It works like that. Liability after retirement. Retired partners still liable for the acts done before retirement. Works like that. Okay. Partnership versus other forms of business. Obviously, there are three major types: partnership, sole proprietorship, and company. In partnership, just please read this tabular formation. It is you will get much more clarity because in terms of members, yes, 2 150 as you know. In sole proprietorship, there is only one member. In company, there is minimum two in private company, whereas in public company, minimum seven. Okay, just remember that. Uh, Liability here it is unlimited, unlimited, and limited. In terms of decision making, joint, quick, and complex. Board of directors would take the decision. In continuity, ends on a death, or obviously in retirement, ends of owner's death. In continuous existence, company can never be died. Legal status not separate from the partners, not separate. Here it is separate. Rising capital, moderate, low, high. Registration optional, none compulsory. Okay. Now moving to the dissolution of partnership and firm. Normally I um when we have been taught by our educators, I would say in my school. So when this topic comes, I remember very clearly the my educator has clearly mentioned with double inverted comma that this is what a firm and partners never want in their life. Because dissolution is something that no one has ever planned. No, because see, now, imagine you started a business. Obviously, you won't think about closing it ever. So normally, but it is tough. It is necessary. We have to decide. We have to think about what if. So we are going to learn about this as well. So let's understand what is dissolution. First of all, dissolution is nothing but just an ending the legal relationship between partners. So there are two types of, I would say, first, a dissolution of partnership, and I would say the second is dissolution of firm. Obviously, as the name suggests, in the first, only the relationship between the partners changes, firm continues here. Whereas in dissolution of firm, entire firm closes, business done. That is what this two type means. But there are different modes. There are around five modes of dissolution. The first is by agreement, like both the partner agrees to dissolve. Okay, like sorted. But the second is by expiry of a term. For example, normally certain two or more people are come together for a certain project or for a certain period. So at that point of expiry, they separate down and closes the firm. So that we consider it as in under expiry or term. Third is by death or insolvency. By death of any partner, or maybe the firm will be bankrupt or something. The fourth is by notice. Let's say your firm has got the notice by a court, or let's say the other any firm out there or any consumer or any user file a notice against you, against your firm, about involving any illegal practices or anything that should say. So by that is something. Now moving to the fifth type, by court order. Let's say misconduct or anything, the court has sanctioned you that you are out of the business. That is also one of the mode of dissolution here. So in terms of dissolution, who are you who are you liable to pay? The first you have to pay your outside creditors, then the partner's loan, then the partner's capital, then after partner's capital, if you have money in your account remaining, I'm talking about the firm's money, then you can distribute it between the partner as much as you want. I would say 50-50 generally. That is what happened. The next is topic 8, registration after dissolution. So I don't actually, I'm not very comfortable with this because I think that it is not that important. So I'm skipping it for now. Partnership at will. Okay, this is important. Partnership at will. A partnership is called a partnership at will when no specific duration is mentioned and no particular project is or objective is defined. When nothing is defined, no objective, no particular project, no time duration, nothing. They just wanted to come and do a commercial activity. So they are binding themselves by an agreement that they are doing a business by sharing the profit and respective liabilities as well. So that is come under partnership at will. So in short, it continues as long as the partnership partners wants. Either partner can dissolve anytime by giving written notice. Okay. Now moving to the last and final topic. After that, this ends. So it is nothing but just a difference between partnership and LLP. Listen it very carefully. I know it is the last topic, but it is very important. So now in the modern term, this is a modern form of partnership. It combines partnership flexibility with company level protection. So understand, we are going to understand it with a I would say tabular representation. So in partnership, the legal status, I would say, not separate from the business, whereas in LLP, this is separate from the business. So it is a much more helpful for a partner. It is partners like is like secure because now if anything happens to the firm, the partner's personal asset will not uh, be sell for the firm's loan or something. And the second, liability in partners, it is unlimited, but in here it is like limited. The third is registration. It is optional. Here it is compulsory. I'm talking about registration as a like proper partnership deed or something. In terms of continuity, in here partnership ends on partner's death, whereas LLP it continues. Governed by in Partnership Act 1932, whereas LLP it is governed by the LLP Act 2008. Why it is popular? Because it is safer and much more credible. Okay, that's it. That's it, guys. That's it. Okay, so what we have learned. We have learned about what is Partnership Act, why it is necessary, its definition. Then we, in topic 2, we discuss about what are the key features of Partnership Act, like an agreement, profit sharing, number of partners, unlimited liability or something. Then after that, we in topic 3, we discuss about the types of partnership, like selective partner, sleeping partner, cooperative partner, and partners by sharing a profit or something. Then in the next topic, I would say after that it is partnership deed, if I'm not wrong. Yes, yes. After that it's partnership deed. We understand that it is partnership deed is nothing but just a written document where partners come together, form what to do and what not to do, and how to resolve if any problem arises in the future. It is about that. So we learned all of that, and Yeah, after that we learned about what are the clauses under partnership deed, how basically what are the benefits of a registration of partnership deed. Okay, how to get registered for partnership deed. We understand the process. First, we get the form A, and we will fill the form A by filling the business name, nature of business, the duration, the purpose, the objective, or something that we submit. We attach that form with the partnership deed that we have and with the fees, the amount that we have. Then we submit it to the registrar of the state, and the registrar of the state will further some add our firm's name and information to the firms, say the register of firms. After that, the registrar issued a certificate. It says the certificate of registration. In the next topic, we understand about what are the rights, duties, and liabilities of partners. After that, in topic 6, we understand about what are the three forms of act. Not act. The business, like first is partnership, the second is sole proprietorship, and the third is uh, LLP, limited liability partnership, and the next is how dissolution works. What are the like there are two types of dissolution of firm and dissolution of partners, and there are around five modes I would say. First is by agreement, the second is by court, the third is by let's say they are limited number of that period that they come together and separated, and the next one is the by death or by retirement or something. Yeah, that is how it is. Then we understand about partnership at will when there is no objective, it's just or no purpose or nothing will be mentioned. Then we consider as a partnership at will. Then when we talk about in LLP, limited liability partnership, we understand how it is different from the partnership and how it is beneficial uh, as over the partnership. Yeah, that is what we have learned, and I hope you guys liked it. So I just be maybe I am too quick, so you can uh, decrease the speed at 0.8 or 0.7 and just revisit the whole session again. I just wanted to make it very crisp and solid, and yeah, that is it. Basically, my purpose in here not it is just to explain you in short. Okay, thank you.